Danielle, would you please read the statement of adequate notice?
In accordance with Chapter 231, PL 1975, the Open Public Meetings Act, adequate notice of this meeting has been provided as required, specifying the time and location, and with such notice as being sent to the Asbury Park Press, posted on the municipal public notice bulletin board, and filed with the township clerk.
Thank you. Would everyone please stand and join us for a flag salute? I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, thanks everyone. Danielle, please call the roll.
Chairman Newman,
Yes.
Vice Chairman Pato,
Yes.
Committeeman Ziner,
Present.
Committeewoman Zabrowski,
Here.
Mr. Lambert,
Here.
Mr. Pepe,
Yes, here.
and Ms. Sinha,
Here.
and Mr. Cipriano.
Here.
Thank you. Today, for the record, Mr. Coffey and Mr. Perino are absent. Mr. Cipriano will be seated for Mr. Coffey.
Okay, thank you very much. On our agenda, we start out with public comments. If anyone would like to approach the board on a matter that's not otherwise scheduled for discussion, this is your opportunity. Seeing none, we'll close the public comment portion and proceed with our agenda. First item are a couple of minutes to approve. We'll do them separately. The first is from February 12th, 2025. Would anyone like to make a motion to approve those minutes?
I'll make the motion.
Thank you. Is there a second?
I'll second.
Okay, great. Any comments or suggested revisions? Seeing none, Danielle, please call the roll.
Mr. Pato,
Yes.
Committeeman Ziner,
Yes.
Committeewoman Zabrowski,
Yes.
Mr. Lambros,
Yes.
Ms. Sinha,
Yes.
Mr. Cipriano.
Yes.
Thank you.
Okay, next is approval of our February 14th special meeting minutes. Would someone like to make a motion for those minutes?
I'll make a motion.
Okay, thank you. Is there a second?
I'll make that motion.
Okay, thank you. Any comments or suggested revisions? Seeing none, Danielle, please call the roll.
Chairman Newman,
Yes.
Vice Chairman Pato,
Yes.
Committeeman Ziner,
Yes.
Committeewoman Zabrowski,
Yes.
Mr. Lambros,
Yes.
Ms. Sinha,
Yes.
Mr. Cipriano.
Yes.
Okay, thanks. Next on our agenda is memorialization of a resolution for U.S. Tank Painting, Inc., Block 16, Lot 9.06. Would anyone like to make a motion on that resolution?
I'll make a motion.
Okay, thank you. Is there a second? I'll second it. Any comments or suggested revisions? Seeing none, Danielle, please call the roll.
Chairman Newman,
Yes?
Committeewoman Zabrowski,
Yes.
Mr. Lambros,
Yes.
Ms. Sinha,
Yes.
Mr. Cipriano.
Yes.
Thank you.
Okay, thank you. Next up is a consistency report, ordinance 25-03. McKinley or Mike, do you want to introduce this for us?
Yes, Mr. Chairman, this is an ordinance review, a Section 31 review. The board is required when the governing body is adopting or proposing the adoption of a new ordinance relating to your zoning ordinance, that it comes to the board for a consistency review to determine whether it's consistent with your master plan. This ordinance is pretty basic. Let McKinley talk about it if she wants, but essentially all it does is adjust fees, and it extends the permitting for trailers and mobile homes from 6 months to 1 year.
And I'll just add to that, it was, if this board remembers, we reviewed an ordinance maybe 6 or 8 months ago about trailers and RVs being stored on site. There was simply either a typo or a slight oversight with how the fees are addressed for these. So this, and the 1 year timeline that Mike just laid out. So this is essentially fixing the oversight from the last time. It has no bearing on the zoning standards that were adopted by the governing body. Just make sure that the proper fees are in place and that the time extension for the senior trailers remains as it always has. I have, from a master plan consistency, I still believe that the ordinance that was adopted is consistent, and this is supporting that ordinance.
Is that for all property in town?
It has to do for, in residential districts where trailers are permitted. There was a previous ordinance that permitted them for an age-restricted or a senior family member. So this allows any of those trailers that were in place at the time of adoption of the previous ordinance to maintain. And then moving forward for any of the newly regulated trailers, it corrects the fees associated with establishing whether they're temporary construction trailers or what have you.
Okay, and as you said in your opinion, this is all consistent with our master plan?
Yes.
Okay, thank you. Anything further from any of the board members? Okay, Mike, would it be appropriate now for a motion to confirm that the board deems this consistent?
Correct.
Okay, so I'll make that motion to confirm that the proposed ordinance 25-03 is consistent with our master plan, and that can be passed along to the governing body. Is there a second on that motion?
I'll make the second motion on that.
Okay, thank you. Any comments? Seeing none, Danielle, please call the roll.
Chairman Newman.
Yes?
Vice Chairman Peto.
Yes. Yes.
Committeeman Ziner.
Yes.
Committeewoman Zabrowski.
Yes.
Mr. Lambros.
Yes.
Mr. Pepe.
Yes.
Ms. Sinha.
Yes.
And Mr. Cipriano.
Yes.
Okay, thanks, everybody. Next up is something that's been dancing around our agenda for maybe a year or two, actually, and it's gotten pushed, mostly by me, as I've been working with Danielle to fine-tune it. These are proposed rules and regulations for the operation of the planning board, and I know it's a little lengthy and a little meaty, but in net effect, and Mike, you can weigh in if you'd like, in net effect, this takes a lot of what's already in the land use law and already the actions that this board takes on a regular basis and our consultants take on a regular basis and puts it into a written form so that, to tell you the truth, my view of it is there's going to be moments down the road where some of us, maybe me, might decide that we're going to step away and want to make sure that the rest of us have a guidebook that we can turn to. And even then, you still have Danielle's expertise and Mike and Matt and McKinley to help guide any of these questions. But it just, at Danielle's suggestion, it seemed like a really good idea to try to memorialize what we do. And we did try to fine tune it a little bit. We didn't just copy and paste from the land use law. So I'm comfortable with it. I've gone through it a couple times with Danielle. And I would ask Mike or any of our other professionals if they had any other comments.
I've reviewed it. It is 99% a reiteration of what the land use law says or what case law says.
So I only added 1%.
I only have one comment that I'm not concerned about because I don't think it'll be an issue, but Section 1:3-2 talks about work sessions, and it says the work sessions are to discuss and study any applications or other matters coming before the board. And the Stewart case in Monmouth County says that that kind of a work session on an application that's already been submitted is inappropriate. You should, if there's an application, you're either having a hearing on the application or you're not.
So how would you suggest?
But other matters, discuss and study other matters is fine. But if there's an application that's pending, that is something that I would suggest to the board. Don't talk about it except at an open public hearing that's scheduled and noticed to the public.
Okay, so with that revision, which Danielle, you can make on the fly, anything else to bring to our attention?
No, the rest of it is
Okay.
fine.
Right. McKinley or Matt, anything to add? All right, so unless any of our board members have any comments or suggested revisions or want to go over anything, I would like to make a motion to proceed so that the board can adopt these rules and regulations. It doesn't mean that they are locked in time forever. As we move forward and as we progress, if somebody finds something that they want to fine tune because we're actually not following that for one reason or another, or we're doing it a little different, or we find something we want to add, we can do that year over year. So with that correction that Danielle will make, and then before she sends out final version, I would like to make a motion to proceed with the board adopting these rules and regulations.
I'll second that motion.
Thank you. Any comments?
Yeah, so we'll get a review on it and then make another vote at another time?
No, my suggestion is that this
But with
will
that correction.
stand, and Danielle will make that correction. I think it's only crossing off 2 words. Is that right, Mike?
That's correct.
Okay, so it's taking out the reference to applications, and it's just other items.
Just delete that.
Okay. All right, unless there's anything else, Danielle, please call the roll.
Chairman Newman.
Yes.
Mr. Cato.
Yes.
Committeeman Ziner.
Yes.
Committeewoman Skrowski.
Yes.
Mr. Lambros.
Yes.
Mr. Pepe.
Yes.
Ms. Sinha.
Yes.
And Mr. Cipriano.
Yes.
Thank you.
Okay, thanks, everybody. Next up is application JLE LLC, Block 20, Lot 3.13, a settlement agreement hearing. So is there someone here on behalf of the applicant?
Yes, good evening, Mr. Chairman. Kenneth Pape of the firm Heilb and Pape.
Mr. Chairman, if I could just make a brief introductory comment
Yeah,
on
please.
this.
Could Mr. Truss also put his appearance on the record?
Go right ahead.
Scott Truss from Herrick Feinstein, also for the applicant. Thank you.
Excuse me.
Mr. Chairman.
Stein, we do have a board member that will be recusing himself from this application.
Yes, Mr. Cipriano should be stepping down as he is a member who has a property within 200 feet of this application, therefore is by statute an interested party and is not permitted to sit with the board on this.
But he can remain.
But he can remain in the room. If he was not a 200-foot resident, I'd suggest that he go outside, but he is a 200-foot resident. He is an interested party, and he should be permitted to remain in the room and to participate if he so chooses. His participation would be as a resident, not as a board member, and you would consider any comments or testimony that he gives as an interested party rather than as a board member.
Okay, thank you, Mike.
That said, this was an application that was presented to the board over a lengthy period of time. The application was ultimately denied, principally on the basis of one variance and some concerns regarding sound. The application was the denial was appealed to the Superior Court, and at the Superior Court conference, case management conference, the judge suggested, let's say, strongly suggested that the parties discuss whether or not there's a possibility of arriving at a settlement of this matter so that that would be satisfactory to both sides. There were discussions. The applicant has revised their plans and submitted a revised plan that pursuant to the settlement agreement that we reached, the board has submitted and indicated that the settlement was appropriate. And as part of that, the law under the Whispering Woods case requires that the settlement be presented in an open public session with an opportunity for the public to hear what the settlement is and to make comments, whether in favor or in opposition to the settlement agreement. And then the board will make a determination as to whether or not to grant the settlement, the application as presented in the settlement or not. Mr. Pape is here and Mr. Truss is here to make that presentation. My expectation is that they will present what the settlement involves, that is what's been agreed to as far as the plan changes. And as part of that settlement as well, as those who are here may remember, there was a lengthy list of conditions that were proposed that would be imposed if the board had granted approval. And those conditions are also part of the settlement agreement, that if the board approves the settlement and moves forward, that they would also be conditions of the approval. That being said, Mr. Pape is here, and I can advise the board that this proceeding was noticed properly. I reviewed service. The service is in order. The publication was proper. The service on citizens was proper, and the board does have jurisdiction to proceed with this Whispering Woods presentation.
Okay, thank you.
With that, we'll go right to the direct presentation of the settlement plan. So, Mr. Chair, board members, board professionals, public, good evening. Kenneth Pape on behalf of the applicant. We'll take you through what I intend to do this evening is to go through the language of the settlement agreement, in particular paragraphs 2 and 3. That's where the elements of the plan are outlined. The balance of the settlement agreement, there's legal terms. I'm not going to go through all of those. I'm going to present the plan to you. If there's anything further after we made that presentation that you would like to, on the record, you'll so advise us. all of the professionals who were involved in the presentation of the application to this board joined us this evening. They asked that they all be here so that there could be, if there are any questions of the professionals, there'll be someone here to answer them. It's my intention to only rely on 3 witnesses to present this application to you. This is essentially the presentation of a settlement plan. The first person is Louis Zugner. Louis is the engineer, as you're aware, who prepared the plan, and he also prepared the settlement plan that was approved by the court. The second witness is Steve Radasti, who was responsible for the building design. There are changes to the building design, so I've asked that he present those changes. And the third witness is Scott Kennel, who is a traffic expert who will confirm that the revisions that have been made to the plan do not in any way affect the integrity of the on-site circulation or the validity of the DOT permit. We do have Allison Kaufman, our planner, Dr. Raymond Walker, environmental scientist, Ben Muller, the sound expert. Everyone is here. I don't believe that they're needed to present the settlement. So with your permission, Mr. Chair, I'll call Mr. Zugner. New hearing, although I think it says it's a continued hearing. We'll have him sworn.
We will indeed.
We'll have him sworn, and we'll go right to his testimony.
And before we go to that, I should advise the board that we have received the following exhibits in connection with this presentation. They include Exhibit A1, that's the jurisdictional notice that I indicated was in order. Exhibit A2 is the application and checklists and administrative forms. Exhibit A3 is a settlement response letter consisting of 12 pages prepared by Mid-Atlantic dated March 19, 2025. Exhibit A4 are outside agency approvals from the applicant. Exhibit A4. Exhibit A5 is a geotechnical report, stormwater management investigation services prepared by Terracon. That's dated January 10, 2024. Exhibit A6 is a traffic impact analysis prepared by McDonough and Ray Associates. That's dated July 27, 2021, revised through March 18, 2025. Exhibit A7 are earthworks plans consisting of 1 sheet prepared by Mid-Atlantic. That's dated April 19, 2021, revised through March 17, 2025. Exhibit A8 are truck turning plans consisting of 2 sheets prepared by Mid-Atlantic. They're dated April 19, 2021, revised through March 17, 2025. Exhibit A9 is a groundwater mounding report prepared by Mid-Atlantic, and that's dated April 15, 2022, revised through March 17, 2025. Exhibit A10 is a stormwater management report prepared by Mid-Atlantic. That's dated July 22, 2021, revised through March 14, 2025. Exhibit A11 are architectural floor plans and elevations consisting of 2 sheets prepared by Perez and Rodasti. They're dated March 18, 2025. Exhibit A12 is a preliminary and final major site plan prepared by Mid-Atlantic. That's dated April 19, 2021, revised through March 17, 2025. Exhibit A13 is an acoustic analysis executive summary prepared by Ostergaard Acoustical Associates. That's dated March 21, 2025. Exhibit A14 is an architectural exhibit prepared by Perez and Rodasti, dated April 7, 2025. Exhibit A15 is an aerial exhibit prepared by Mid-Atlantic. That's dated April 9, 2025. Exhibit A16 are site renderings consisting of 2 sheets prepared by Mid-Atlantic, dated April 9, 2025. In addition, we have board exhibits, including a completeness and engineers review that's dated January 20, 2025. That's PB number 1. PB2 is your planner's review. That's dated February 12, 2025. Exhibit PB3 is an LTE review. That's dated April 9, 2025. That's your tree experts review. And Exhibit PB4 is the fire officials review. That's dated March 20, 2025. Those are the exhibits that have been submitted in connection with this proceeding. And
With your
Mr.
permission.
Zugner, why don't I swear you in? Raise your right hand and be sworn. Do you swear or affirm that any testimony you give in connection with this proceeding will be the truth, whole truth, and nothing but the truth?
I do.
And your name and address for the record, please.
My name is Louis Zugner, Zuegner. And address is 392 Thompson Mill Road in New Hope, Pennsylvania.
Mr. Zugner previously was qualified as a professional engineer. His credentials were placed on the record many, many, many months ago. I'm going to ask him if his licenses are all in good standing this evening. And Mr. Chair, I'll ask with those statements if he can proceed.
Okay, go ahead.
Mr. Zugner, could you confirm that your licenses in the state of New Jersey are in good standing on this evening?
They are, yes.
And Mr. Chair, then I ask that he be allowed to testify as a professional engineer as he has placed on the record previously.
Okay, that's fine, thank you.
Thank you. I'm going to ask if you could begin by identifying the exhibits from which you intend to rely, and then we'll go through.
So we have 3 exhibits, although 2 are really the ones that I intend to use. One is a colored rendering of the site. I'm not sure how this is numbered, but
I think it's up. Louis, I think
Yep.
Ms. Sims has it.
That's-
Daniel, what's the number for this one?
This one's A16, it's the two sheets for the Mid-Atlantic site plans.
Thank you. And the second exhibit from which you'll rely?
And the second exhibit is also a rendering, but this is a closer in image. This one's entitled Site Modification Exhibit.
That was page 2 of A16.
They're both dated 4/9/2025.
And using the exhibits to assist in the presentation to the board and to the public, I'm going to ask that you work with me. We'll go through the language of the stipulation of settlement. The stipulation of settlement at paragraphs 2 and 3 contain the detailed revisions that the applicant is to make to the plan. And if you're ready, we'll go through them, and I'll ask that you confirm that they're on your plan, and perhaps you can identify where they are in the plan.
Certainly.
The first, in paragraph 2 of the stipulation of settlement, the first requirement is that the applicant shall reduce the building by 10,000 plus or minus square feet. If you could confirm that the plans that you're presenting to the board do show a building that is reduced in size by 10,000 square feet.
The building is reduced in size.
The building is also to be relocated further away from the properties to the northwest, and the order actually states that it shall be 34 feet further away from the residential properties to the northwest. Does your plan show an increase of 34 feet from that property line?
Yes, it's 34 feet further from the property line, and that's the element of the building that has been reduced.
There's also a requirement that the loading bays in the northwest corner of the building shall be modified. 23 loading bays were to be removed so that there's no loading activity in the northwest corner. Can you confirm that the plan that we're looking at, and maybe you could point to it for the benefit of the board and the public, the plan that we're looking at has 23 loading bays that have been removed?
So they actually have removed 26. So when we worked with Mr. Radasti, based on the configuration of the building, there were 26, so 3 more removed than the stipulation. And they're all removed, as you can see, at the back of the building.
There's also 11 loading bays that are in the southerly side of the building that will have restrictions on use. They're restricted to smaller trucks and van vehicles. If you could identify where that is on the plan.
Ms. Sims, if we could switch back to
Page 2.
exhibit number, page 2.
This is page.
Page 1. I'll just show for a moment. There's also an inset showing it if you scroll down just a little bit. But along the front parking, you can see the island that's brought into the parking area. Thank you. There's a segment of island where the parking lot, the yard area is less in depth, and it's those 11 loading bays that have limited or less dimensional access.
And your plans include notes that confirm that those have restrictions on their use?
The plans do have those notes.
The sound wall in that area of the property was to be relocated so that it would be a minimum of 50 feet from the property line. Could you confirm that the sound wall has been so amended?
The sound wall can be seen on the rendering in a blue color, and has been pulled to 50 feet from the property line.
The updated plans are to have a reduced impervious coverage, which would then result in reduction in stormwater impacts. Could you confirm that the overall impervious coverage of the plan has been reduced from the original plan presented to the board?
In the changes that have been made, the impervious coverage is less.
The berms that are along the northwest side, the language of the settlement says that the berms shall remain as originally designed, their location, their size, their height. Could you confirm that all of the characteristics of the berm along the northwest corner of the property are intact without revision?
All of those berms are still as they were originally designed in prior plans.
The next requirement is a sound engineering report is to be submitted on behalf of the applicant. That was submitted. I trust that your sound expert will comment on it. I have no comments of Mr. Zugner with regard to that. The next is that there's a requirement that the 15 spaces of trailer staging area that was originally shown in the northeast corner is to be removed. Would you confirm that there's no longer any trailer staging as part of this plan?
The trailer staging spaces, those 15 have been removed, which is all of them. There are no longer any.
That is the elements that appear in paragraph 2. Paragraph 3 states that any resolution that's adopted by the board shall incorporate further conditions, and the conditions go from A to double G. I look to you, Mr. Stive. I'm prepared to go through those, similar to what we just did, or to stipulate that those are all elements that will be part of the resolution pursuant to the settlement. If there's a preference, I'll go through them.
That's at the pleasure of the board.
Those are all,
Those are all conditions that were set forth at the final meeting that we had previously, and they're all the same. They're all conditions that were recommended as part of the conditions of approval, and they remain the same.
We accept them in exactly as written. There are two questions that require input from the board, however. One that says the 6-foot fence that's to be installed along the western border is either to be a chain link or a vinyl as the planning board directs. So we would look to you for direction as to whether or not it's chain link or vinyl.
And that's condition K.
Correct.
can you just show us on, Mr. Zucker, on the plan where that is?
So it runs along the length of the northwesterly property line, and you can see a sort of dashed black line on the rendering.
Okay, so Mr. Pate, the question for the board is our preference chain link or what I'll call a solid vinyl fence?
Yeah, the language in the order is very, very clear. It says, provide a 6-foot high chain link or solid vinyl fence, parens, material as directed by the board, close parens, along the westerly property perimeter to separate the property from the residential community to the west. So we would look to you for that choice.
McKinley, from a planning perspective, do you want to give the board the benefit of your thinking?
McKinley, do you either swear or affirm that any testimony that you give in connection with this proceeding will be the truth, the whole truth, and nothing but the truth?
I do. I think if we're looking at this in relation to a lot of the comments that were brought up by the residents in terms of creating a separation and safety, a solid fence would probably be more appropriate, especially if we're talking by closer to their resident lines. For continuity, it would make sense just to keep the same material all the way. So I'd recommend the solid fencing option.
What colors could we get?
I'd have to defer to the applicant on that one.
What's available? I don't know what's available.
There's everything from black to brown to taupe to gray
It sounds like
to white.
if taupe or green or black would be probably better than white. Because in your head, you naturally think of white, but we're trying to hide it, right? We're trying to hide the whole thing. So
I think we want a muted
Earth
Tone.
tone.
Yeah,
Definitely not white.
yeah.
Okay, so Chris, I'd be comfortable with that direction, a muted earth tone, not white, and allow the applicant to work with McKinley for a final
Yeah.
decision.
That works for me.
That works for us.
Fence go all the way out? What is this stuff?
We actually worked that out during the settlement. We're going to show, it's intended to separate us from the residential community.
So I could show you on the other rendering, it might help, but it does go
Does it stop right at the residential zone line right there?
It goes
no, it
all
goes
the
all
way
the way
past,
back
It goes
behind
all
the
the way back.
berms, yes.
Yeah.
behind the berms.
Thank you.
Doesn't go in the wetlands. There's another input that's required, and that is the applicant did place on the record a willingness to landscape a portion of an adjacent property owner's property, subject to that person allowing us to enter, and subject to working out the landscape plan with your, I think you now have an arborist and with your professionals. So we place on the record that we're prepared to do that, subject to the owner allowing it. That's block 40, block 20.01. The balance are, they're explicit, they are point by point in the order. We can address them, or we can place on the record that we agree and adopt each and every one of them.
So, Mr. Page, you said you had other witnesses you wanted to
I
present?
do, I have Mr. Radasti to just do the architectural elements of the building.
Okay, and then at some point, I do want to turn to Matt and McKinley and our acoustics expert for their thoughts. There's also some notes in Matt and McKinley's reports that, and as well as of our arborist, that talk about follow-up items that need to be addressed. So we'll have to get to that.
I think there's a report by them that said that they will address all of them. Like there's a letter or something from you guys that says that.
We met,
They will comply with all those items that you see there.
and we had a TRC with your board's professionals and went through the reports. I think there was one typo about the dimensions in one of Mr. Shafai's comments that needs to be corrected. It was in our favor. It needs to be corrected. And there's also a comment about environmental cleanup of the property, and we reviewed the reports. There is no environmental cleanup.
All those comments from my previous report, I just put them back in there again, so they will comply with it like they said they would last time.
And similarly, we went over the
Yes.
report with Ms. Mertz, and I think we're in full agreement with Ms. Mertz's comments. This morning, we received Shari Spiro, the township's new arborist report, a very thorough report. We're used to Shari Spiro's very thorough report. We're comfortable with all of the points that she raised. There's some plant material replacement, she's looking for some supplements. But we can adopt that report as written.
So the only question I had on the report, so we'll just stay with them for a minute, was, Matt, in your report on page 4, item L, or 6L, I guess, it says, it reads, "The traffic report anticipates no truck traffic on any township roads, including Dugan's Grove Road." So the question I have for the applicant, or for Matt, is how do we enforce that? We won't know which trucks.
I mean, their only access is to Route 33, that's what they're gonna use going back and forth. If
So it's
somebody
not,
makes
it's
a
not a
law.
restriction, we expect that they won't use it. There's no way for us to enforce
I mean,
that.
somebody may go there for some reason, but they shouldn't.
Okay, so the only, and I'm with you, Chris, and I understand that dilemma, but could we at least ask, as, you know, we try to push this issue, that the applicant agree that they will, to the maximum extent possible, communicate and coordinate with the truck drivers that they are to stay off of township roads?
I mean, maybe because, I mean, that's a little unrealistic too, right? So is there a sign that you
Right.
could post in short verbiage that somebody could glance at and understand? that there's limitations to what they should, and, you know, there's different ordinance about like braking and stuff like that on a truck driver, so forgive me, but maybe there's something like that.
Yeah,
But I
that'd be
think there's
great.
an ordinance, to be honest with you, for tractor trailers, that they're not supposed to drive through town, and we do have them drive through town. Fact of the matter is that in this town, we don't have any sort of enforcement on our police, so we can do this, but in reality, it's kind of nothing.
So
But for the sake of doing it, why don't we do it?
Sure.
We've already shown signs that were part of the order, there's no jake breaking, no.
Right, that's in
So
here.
Yeah,
that, those
thank you,
signs are
thank
on
you.
the site, and we can add a sign, it's not uncommon, we're doing it throughout the state. We can add a sign that directs to the drivers that specifically states, no traffic from this site shall use a municipal roadway. We can put that sign on the driveway coming in and coming out. It's
It'd
not
be
an
nice if
issue.
there was an ordinance that corresponds to that, so there's a fear of getting a ticket.
I can't do an ordinance.
I can't either, but maybe somebody else can. Maybe you just put a fake number on there.
Yeah, there you go.
It works just as good.
If we're gonna be making stuff up, this is gonna get a lot easier.
I guess. But that'd be good if you could consider that, that's.
Sure,
Okay.
I think it's a great recommendation.
All right, thank you. Anything further, McKinley or Matt, that you wanted to highlight?
I just want to note that I did speak in our TRC meeting and I spoke with their planner. I had called out what I think was a typo where it did trigger a variance for their drive aisle width in their parking lot. It's noted as 24 feet where they had previously stipulated 25 feet. They would meet the requirement of 25 feet. They have once again said that that is just a typo. They'll fix it on the
Yeah.
plans. There's no extra
Plan's
variance required
fixed.
for that.
Just the number's not fixed.
Yeah. Not a big one, but it does eliminate that variance, so that's important.
Okay, and, not to interrupt,
Yep, I'm
all
done.
good? All right. Ben, I do wanna make sure we have you sworn in, and, if you could give us just a quick summary of your report?
Yes, do you swear or affirm that any testimony you give in connection with this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
And name and address first.
Matthew Morello from Lewis Goodfriend and Associates, 415 Route 24, Chester, New Jersey.
Okay.
Not bad. Not
Yeah,
bad.
I apologize. All right.
I was looking for it.
So if you could give us and you've been previously qualified as an expert for this board, so that
Yes,
continues.
I have.
All right, go ahead, please.
Thank you, Mr. Chairman. So I reviewed the Ostergaard acoustical report dated 21 March. I believe it was exhibit, written down here, A13. And all of the changes that were discussed by the engineer by moving the building further away, reducing the number of docks on the northwest side, as well as eliminating backup alarms and nighttime movements, do appear based upon the revised acoustical evaluation to reduce or to lower the sound level at the northwest property line. There still may be, if trucks maneuver on the other side, on the Route 33 side, slight exceedances in the nighttime noise regulation. I don't think that they are anything that it would be atypical for the Route 33 corridor. I would follow up with the recommendation we had originally, was if this board does have a successful settlement, we would recommend a post-construction noise survey be done at the residential receiving property lines, and that result be submitted for a review. But other than that, I have no other.
And what
And
happens,
that's still in the conditions of approval.
what happens if we do that post-construction noise analysis and it doesn't meet it? What happens then?
You want to answer that, or you want me to?
No, you go in and out.
Because they're going to say the same thing. The applicant is required to meet the noise regulation as they would any other speed limit in the municipality. If the noise testing comes back and it exceeds the nighttime or daytime code at any point during their normal operations, they would be required to do whatever necessary to get it within compliance. That could be all kinds of things, even as much as not having any nighttime trucking. I don't know, in an extreme, only one cup of coffee circumstance, but they would be required to get the facility's noise into compliance with the code, regardless of what their studies are.
We discussed it at the original hearings a lot. It's modification of activities on site, elimination of what was causing the sound. But and we accept that. And that language that was just put on the record by Mr. Morello is one of the paragraph 3 stipulations that would be in the resolution.
I'm trying to be sensitive, so you know where I'm going. I'm trying to be sensitive to the residents there, because we don't really have code enforcement per se, like regular towns or police and stuff. If there is a situation where it is in excess of whatever we've agreed to here,
Yeah.
it's difficult for them to manage that, right? They're gonna become frustrated neighbors, that's not good for the owner of this property and the tenant and so on and so forth. They're gonna feel frustrated as residents in town, they're not gonna know where to go. I suffer from some of this myself where I live, and I don't have the ability, or I don't have a way to react. There's nobody for me to tell. So I'm sensitive to what may be a problem for them. So I'd like to get it to a situation where we don't even open up the door for it. It sounds like, because there may be a situation where we may get over this sound issue the way it's designed today, I personally would like to just see it arrested, or, or do something more to sort of assure we don't get into that. Now, it doesn't sound like that's really an option, right? But what can we do? What more can we do? Imagine we do exceed it, imagine that resident lives back there, that resident's upset, as opposed to that guy, what's he gonna do now? He comes to the township committee goes, yeah, we'll send somebody out, and so on and so forth, and nothing quite happens.
Well, don't they go to the Monmouth County?
Yeah, so if I may, the two
Please,
things.
please, help me
One is-
out.
And what Matt, his point is correct. Residents are encouraged, if the municipality doesn't have a noise control officer, which doesn't sound like you do,
Yep.
the county health office has an enforcement arm that can be called at no cost to the resident to enforce the noise regulation of the state of New Jersey and the municipality. So the municipality's noise regulation is consistent with the DEP.
Riddle me this, if the resident suspects it's in excess, can he call that agency, they'll come out, test it, and conclude what's true and what's not true?
Correct.
They'll make us test it.
Not only
Okay,
can
they'll
they,
make you
they
too.
are required to, yeah.
Okay,
So they're required to, as any health agency, to follow up on any and all complaints. So if a resident does complain about the noise or any other environmental concerns they may have that the municipality doesn't have the ability to enforce, the county health officer would be required to investigate and determine whether an exceedance exists or not. Daytime or nighttime, weekday or weekend, it doesn't matter. That's their responsibility.
gonna give you another question, I don't know if you're gonna get this. Just out of curiosity, considering you seem to be, you are an expert at this, how backed up is that office? If I call that office today and say I got a problem, when are they coming out to see me?
I have no idea in this county. I can tell you that if there is a complaint, it is investigated and measurements are performed. In every county health office that I've observed,
Yep.
and again, I haven't done all 21, and I certainly don't work in them, I have no idea how backed up they are.
Yeah.
But if there is especially if there is a repeated complaint, or there's a complaint on multiple locations around the site, they will expeditiously get to
Mr.
it.
Pape, you have any insight to that?
I do, I want to be careful what I,
No, I get you don't work there, and I get you're not passing comment on it, I'm just curious.
I was going to say this county has, the county health office is where all sound regulation is being enforced. And our experience is that when someone files a complaint, they immediately reach out to the property owner and say a complaint has been filed and directs them to the sound testing.
Thank you.
And it's,
It usually happens pretty quickly.
the Monmouth County Health Department's, they're great.
Yeah, I'm asking your expertise, I know you're not,
Usually in a few days.
So
Okay.
I can actually answer a little bit better too. So Chris Merkel in the Monmouth County Board of Health is actually who is assigned to Millstone Township. And I've actually talked to him several times on the phone about noise, and he's always answered the phone. Like, when I've
Great.
called, like, I've never gone to voicemail. When I have called Chris about a noise issue, he has always responded.
Great, okay, that's good. I hope that gives everybody a little comfort too.
Do have a question. I'm looking at Exhibit A13. It's still an old diagram of the warehouse. Is there an updated sound study with the warehouse in its present
There was
proposed condition?
the sound report that was generated on March 21, and the one that your expert has commented on, did not run all of the numbers. What he did is he went through each of the positive changes that had been made. And that's what was submitted to your expert for review.
Okay, I'm just looking at the diagrams though, and it looks like it's an old rendering of a plan that was like a year ago.
It's the new plan. It's the new plan. It's just, the plan looks very similar to, there's 34 feet of the building has been sliced off. And the driveway system comes closer to the,
Yeah, I see what you're saying.
So the building is on like a 2 to 8 angle and not a 9 to 3 angle.
the angle
Yeah, I
isn't-
actually see what he's saying. It's the way the tilt the building is.
That means the harmonics will be off because of the slant of the building. I'm just wondering if a new study was done with the rendering that you have present.
Yeah, see, that rendering that you have up there does not match your sound one. That's what he's saying. It's still the old tilt of the building. That one is not the same.
I think it's a different perspective on the same image.
No, it's gotta be tilted.
That's north.
So 33 on ours is straight at us, if we're looking at it.
You're looking at a rendering there that the building, I say, is like a 9 to 3 position.
Yeah, it's different than on this.
What's in the submitted documents, Exhibit A13?
So A13, we're looking at
It's
the
at,
building at 33 this way.
it's almost like a 2 to 8 angle,
Yeah.
like a 30-degree angle from where it's at right now.
Can
Isn't
you
it just
confirm
the-
that the plan that, is it
I think-
before you?
I think
It's
actually
just
it's
the
because
perspective.
that north is not straight up. Or where Mr. Mueller's report,
Yeah, you see the
north
north
is
arrow.
straight up. I think if, yeah, so that's more
Compared to
north.
straight up.
Yeah.
the side property line.
If you look at the angle of the front of the building relative to Route 33, that looks about right, if you get north to be straight up.
Okay,
The plan that is before you is the plan that was delivered to Ben for his report.
okay, thank you.
Right.
Okay, anything else from any board members before we go on to the next witness?
Go to Mr. Radasti with permission.
Yeah, sure, and Mike, unless you guide us otherwise, I was gonna wait till the witnesses are done to open up to the public.
public for all.
Yeah,
I'll go
okay,
for
go ahead, Ken.
Okay, thank you. Steve Radasti is our architect. There's some minor changes to the building, reducing its size, that I'm going to ask that he address. There are also some of the requirements that appear in paragraph 3 of the settlement that I've asked that he also address. Mr. Radasti previously
Before he
testified.
starts,
Swear
let
him
me
in.
just swear him in. Sir, raise your right hand and be sworn. Do you swear or affirm that any testimony you give in connection with this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
And name and address.
Stephen Radasti. It's Perez and Radasti Architects, 379 Princeton Heights Town Road, Cranberry, New Jersey, 08512.
Mr. Radasti's credentials as an architect are part of the earlier record. I'm going to ask, are all of your licenses in good standing this evening?
Yes, they are.
And then Mr. Chair, I'll ask that he be permitted to continue testifying as a professional architect.
That's fine, thank you.
Thank you.
Thank you.
If you could identify to the board and the public the exhibits that you intend to rely upon to present your testimony.
So I produced two new exhibits. Exhibit A11, which is sheet SK1, floor plan 318, dated 3/18/25, and SK2, colored elevations 3/18/25. They're both exhibit A11. And then I have a new exhibit, A14, which is called CS1, north elevation, and revisions to floor plan, and that's dated 4/7/25.
So what would you like to have in front of the board as you begin? I'm going to ask you about building size and changes to the building's purpose.
Yes, so there would be exhibit A14, which it looks like
Yeah.
it's loading right now.
So you saw the plans that were prepared by Mr. Zugner. You saw that his plans show the building was reduced 10,000 square feet in size. Would you confirm that you have similarly on your plans reduced the footprint of the building by 10,000 square feet?
Yes, I have.
And also you saw on the plans that were prepared by Mr. Zugner that he identified, I said 23 loading bays were removed, but apparently you got bold and you took 26 off. Would you confirm that there are 26 less loading docks on your building in the northwest corner?
That is correct. We took away 26, and it goes from 96 to 70.
There were a couple of points that were raised in the settlement. I just want you to affirm. The warehouse building roof is designed to be solar ready.
That is correct. It'll be designed for the structural loading of future solar panels.
And the design of the building has the recyclable material stored inside the building, not outside into the parking lots.
That is correct.
The warehouse group class that we've identified to the board and memorialized in the settlement is use group S-1. Would you confirm that that is the use group that was designed to?
Yes, that's correct. It's designed to be S1, which is moderate hazard storage. This means that the building can store combustible and non-combustible goods, and no hazardous materials can be stored in the building.
The roof air conditioning and heating units for the offices are fully concealed by the parapet on your design.
That is correct.
The warehouse has no air conditioning, but has radiant heaters? Is it?
Yes, it'll have interior radiant heaters, correct.
Okay. And if you could confirm that the building continues to be designed to accommodate 1 to 4 tenants and that there's no public warehousing that is part of the building design.
That is correct.
I think those were the architectural elements that appeared in the settlement document, and I have nothing further of Mr. Radasti.
Yeah, and what are we looking at on the screen? What is that telling us?
So on the screen, I have the revised floor plan, and basically in red on the left-hand side, it shows the 10,000 square feet that were reduced from the building. So the building was reduced in length, but not in depth. So we're reducing it 34 feet, 4 3/8 of an inch shorter. So that works out to be the 10,000 square feet.
Okay. All right, so I want to make sure there was nothing else on the exhibits you wanted to highlight for us.
It also, if we could scroll up to see the top of the sheet. I also have the north elevation here, and this shows the deletion of those garage bays, the 26 garage bays that are removed. You can see it on the right-hand side that all those bays are gone.
Okay, thank you.
Thank you.
Anything further, Mr. Craig?
Nothing further, Mr. Radasti.
Okay, any questions from any board members on this or our professionals?
And the building facade is what you showed last time, right? When we hear nothing's changed as far as the colors and all that?
All the colors are the same, the materials are the same. Basically, the difference are the reduction in bays and a smaller size.
Thank you.
Okay. In lieu of the bays, what are those 1, 2, 3, 4, or 5 things that look like doors?
Those are man doors, and they're a requirement for fire department access to the building. They have to be a certain distance apart so they can get in if there was a fire.
Okay, just curious, thank you. Okay, I think we're ready for your next witness.
Fine. The third witness that we intend to
Thank
call
you.
this evening, Mr. Chair, is Scott Kennel, our traffic expert. Again, Scott Kennel testified before the board.
Sir, do you swear or affirm that any testimony you give in connection with this proceeding will be the truth, the whole truth, nothing but the truth?
I do.
Name and address, please.
Sure. Scott Kennel, Kennel, with McDonough and Ray Associates, located at 1431 Lakewood Road, Manasquan. And I just need to qualify. I was at all the hearings except for one. And the one hearing I was not in attendance. My partner, Jay Troutman, had done its traffic testimony. So just so that's on the record.
And I'd ask if you could confirm that the credentials that you shared with the board, that they relied on qualifying you as a traffic expert, remain in full force and effect.
That's correct.
Wait, it's got to go for a detail. But if you didn't testify at the prior hearings?
You did.
No.
Oh, you did?
Well, you attended.
I attended all the
Yeah,
hearings.
so let's go
I've
through the motion.
I've been qualified by the board before on other
Right,
applications.
sorry, thank you.
Okay. So let's go through that, Ken.
Okay.
Mr. Kennel, please share
Yes.
with the board your professional.
Yes. I'm a principal with McDonough and Ray Associates with over 35 years of traffic and transportation planning experience. I've testified before this board as well as the Millstone Zoning Board, as well as in 100 municipalities on over 2,000 site plan applications. I've been qualified by the New Jersey Superior Court as a traffic expert on 4 land use matters, and I've prepared over 500 NJDOT access applications.
I ask that you accept Mr. Kennel as an expert in his field and allow him to testify this evening.
Yes, that's fine, thank you.
Thank you very much.
Thank you.
Mr. Kennel, I'm going to ask that you be succinct. There was an NJDOT permit secured for this property. It was the driveway access onto Route 33. I would ask, with the revisions that have been presented to the board, does the NJDOT access permit remain valid and in place?
Yes, it does.
And there's been some minor modifications to the driveway system around the building, particularly in the northwest corner. Could you confirm that you have reviewed the plan, that you reviewed the circulation plan, and that the circulation plan remains safe and adequate for all anticipated vehicles, including emergency service vehicles, trash removal vehicles, and the anticipated tractor-trailer traffic?
Yes, it does.
And finally, I'm going to ask if you could confirm that your report identifies that there's no intended use of the municipal road system to provide access to the site.
That is correct. And it's also noted that there is also a 5-ton weight limit on Dugan's Grove Road as well, just for the board's benefit.
I have nothing further of Mr. Kennel. I needed that he confirm that these revisions were made, did not affect the validity of the on-site circulation system.
Anything from any of our board members or professionals?
I have, if I may, I have not a question, rather a statement. I just find it very odd. I just was looking at the picture. To the northeast, the tenant, I guess the main entrance for the tenants on that side of the building, the right side of the building, if I was going to visit them or I was working at that tenant spot, I have to make a right and go past all the truck bays to get to that parking lot. Is that true?
That's correct.
Doesn't that seem odd to you?
It happens on many other sites I've worked on.
I mean, I'm just, I mean, you know, I know, but if you're leaving, you're going to be leaving the back of the building and going, it's almost like
Again,
going through a
majority,
work area, you know.
the majority of the passenger vehicles on site will be employees who are familiar with the operation. This isn't a transient type of traffic activity. So this is a known entity for those that are using the site.
It just seems odd that, you know, you're driving through a truck bay area to get to an office area or whatever have you.
So is all the traffic going in one direction or is it bi-directional?
It's a two-way traffic aisles around the building.
Two-way or all around the whole building?
That's correct.
Okay.
Consistent with the prior site plan that was submitted to the
And
board.
that's for trucks and for autos?
That's correct.
And that's always been what was proposed, right?
That's correct.
There's no change in the circulation.
I have to ask, since we were focused a few minutes ago on the topic of truck traffic, staying off of local roads, we came up with some ideas. As an expert in this field, is there anything else we should be thinking about to perhaps additionally control that?
I agree with what was suggested as far as, you know, if we come up with some type of signage, and then it's, you know, the operators of the facility just have to convey to their operators or truck drivers the need to stay on state and county roadways.
Okay, all right, I just wanted to see if there was another thing that we hadn't considered that you've seen out in the industry. Anything else from any board members or professionals? Seeing none? Okay, so that was your...
That is our direct presentation, if you're comfortable with us adopting the conditions of paragraph 3.
Okay, so at this time, Mike, unless you direct otherwise, I'd like to open it up to the public for any questions. And I think because the witnesses have concluded,
Questions or comments?
yeah, I think we're open for questions and comments. So we'll open it up to any members of the public. If you'd like to speak, please approach. Danielle will get you a spot. And I don't know if that mic was working, Danielle, so give it a tap. All right. Well, that's okay. Angela will figure it out. Oh, okay. All right, would anyone like to approach the board? Your name and address, please.
Brian Scott, 19 Arrowhead Way.
Mr. Scott, let me swear you in. Do you either swear or affirm that any testimony you give in connection with this proceeding will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Can we take a peek at the sound diagram again? My biggest concern is that for 18 months, we've kind of pushed back to say, let's reduce the size of this building. Let's make it no unreasonable doubt that there's going to be any issues with any of the residents next door. Never once did they take any of the community consideration, not the attorneys, the experts, the property owner. No one cared about what we felt as a community member, okay? What happened was they found out that their application was denied, and they went behind our backs, they did the litigation, and they went that whole route and threatened the town and everything like that. It's not fair to us as residents to have backdoor dealings, okay, and come up with some sort of settlement, come up with some sort of agreement without our input, okay? So now, we're back to the same square that we were months ago with the issue of sound, okay? Because conveniently, we put these large, loud sounds around the building in spots that do not direct that sound towards those residential units. So again, from my testimony and my ask months ago, why are we not putting one of those direct sounds right here? This is the closest point to these residential spots. On this further down, there's a spot here, there's a spot here, a spot here, a spot here. Why are we not here? The burning starts right here. If you look at the diagram that has the sound here, it's approximately this far. It's right in my backyard. I got a baby on the way now. So now you got a different person. I don't understand why we have to push the limit to the most extreme max and not take into consideration the town's concerns. Because what do I have to do? I gotta continue calling the Board of Health and get this guy in my backyard every single day? When I have sounds, and then what happens on the weekend when I have a barbecue and there's sounds? I'm not calling him on a weekend, he can't come, and he's gonna come when the sound's not happening. So we're just gonna constantly test this thing. What are we gonna do? Tear another 10,000 square feet off the building? Come in with an application that makes sense. I don't understand why it's so hard. Can you give me an answer on that?
The plan that has been presented to you is not something that was done backdoor. It was not done sneaky. This was done through the courts properly.
I wasn't privy to it, and I'm a resident of this town.
And I take offense to the remark that it is anything other than done properly. With regard to the sound generators, the goal was to remove the sound generators that were in that corner, and we did, and to pull the building further away.
Okay, can we go down to
The
two
report,
slides then?
the report that was generated initially and the report that's generated now was reviewed by your professional, and he found that at both times, the sound attenuation was done properly. So,
One, two more, to the last one. Okay, so I'll ask our expert if he thinks that this sound and the distance that this is creating is safe if it happens on this corner of the building in my backyard.
I'd like to go to figure B of his report,
Which page is that?
7. Whoop, that one. That is the closest loading dock area to your house, as I understand it.
Correct? And what about an air brake on the corner?
You're gonna have to ask the expert on that. I'm telling you that they
Okay,
did.
then I'll ask the sound expert.
If you're gonna let me answer.
Well, it's just frustrating, because we've been doing this for 18 months, and this has been a concern, and they still don't care. Just make the building smaller, give us no reasonable doubt to ever question any sound coming on our property. It's not that difficult. You don't care about us as residents. The owner doesn't care, he's been pushing it, the lawyers don't care. Come on.
we stand by the plan that has been submitted, that it does address all of the concerns that were brought to it.
Can you guarantee there's gonna be no sound in my backyard? Can your sound expert guarantee there's gonna be no sound in my backyard that's over the limit? No, you can't, because your report says that there may be slight exceedances. The report says it right on the second page. It says there's a potential for slight exceedances. So no, you can't.
In the front of the building.
Thank you. If I have anything else, I'll come. You can't guarantee no sound.
Thank you. Anyone further? Your name and address, please.
Jacob Mendelson, 16 Winding Creek Drive.
Sir, would you raise your right hand, please? Do you either swear or affirm that any testimony you give in connection with this proceeding be the truth, whole truth, nothing but the truth?
Yes.
Go ahead.
Okay, so I have two questions. Number one, how tall is the building going to be? I noticed in the agenda that like 10,000 square footage has been removed. So I'm wondering how tall it's going to be and what the line of sight is going to be for the residents to the building. Like, are we going to be able to see the building from where from where we are to where it is?
It's 30 feet tall. It has not changed in height. There's no variance associated with its height. And they very well may see the top of the building when the building is built.
Okay, thank you.
Okay, thank you. Any other members of the public? Okay, seeing none, we're going to close the public question and comment portion of the meeting. And unless there's anything further from the board or its professionals, Mike, I'd look to the applicant to sum up or wrap up.
Sure.
Before we sum up,
Yeah.
so I respect that the resident is concerned about that sound in that location. Is there any more berming? I mean, I get it, but
It's
is,
975 feet long, 17 feet high with a sound wall on top.
I mean, can we extend it to that corner as well?
We went through all of this
I
with the
know.
board where it should be.
I respect it.
There's 93,000 cubic yards of fill that are to be removed. Before we remove it, we'll see if there's, working with your engineer, if there's any place where we can enhance the berms. 93,000 cubic yards of excess soil, we'll try to use it. We worked, the berms have been designed with your staff.
And I get it, I totally get it, but knowing that we all, we continue to work together as residents and as a board and with you, if we can somehow, if we have extra soil, I know what we've planned out, I know it's been accepted, I get it all. But to just make somebody comfortable for a little extra effort could make just this thing a little more palatable. So whatever that effort I'm asking for, if it could be considered, I think it would go a long way. I also think for the sake of the tenant who lives there, a peaceful neighbor is a much better neighbor. And that may be in everybody's best interest. So could it just be considered at the very least? Matt, can you understand what I'm saying? And
Yes.
do you think it's unreasonable?
I
Is it?
will work with them during construction, try and get more berms out. There's not much, it's kind of tight
No,
in the
and
building.
I get it, and I get we're going 18 feet, and I get it.
17.
So I get it, I get how hard it is, and I understand how hard it is to build and be narrow, I get it all. But in this case, somebody's asking for something, and this is definitely the time to address it, as opposed to the time where the guy's complaining, and the guy who leases this property is dealing with somebody who's not happy. It doesn't work for anyone.
We would be comfortable if one of the conditions stated that before the 93,000 cubic yards is removed from the site, that we'll explore with your engineer if there's any additional location where the berming can be added. And we recognize that there's a focal point that you brought to our attention. I think it'd be important to make that focal point part of any resolution we adopt.
I appreciate that, thank you.
All right, thanks for bringing that up, Chris.
Thank you.
Okay.
Mitch,
Yeah, go ahead.
it's just a question. So, your traffic person said that there's a limit of how much ton of trucks can go.
There's a 5-ton limit on that section of roadway between
So-
Indian Head and 33.
And then, so who would, like, if we wanted to say we want a sign on that road, would that county be putting up a sign, or like to
On
say,
the-
hey, limit truck, limit, weight limit, things like that? Not you guys, I just wanna know if he knows who could be contacted. Just the informational
It's a
reason.
town road, we have to do it.
You have
It's
to.
your road.
If it's a county road, the county does it. And it's a process that DOT has to,
That's my question.
it's not that we can't just do it.
Matt, do you either swear or affirm that the testimony you just given or any additional testimony
I was
you may
waiting for
give
that.
is the truth, whole truth, and nothing but the truth?
I do.
That's right.
Okay, unless there's anything further from the board, you want an opportunity to sum up?
Unlike an application that is fresh, I don't think that summation is necessarily appropriate. What the summation would be this: there were very specific terms set forth in the order. Each and every word of those has been gone through thoroughly by counsel for the board, counsel for the township. What we have presented to you is we are in 100% conformance with that, and we agree to work with your staff so that resolution compliance is carried out consistent with the stipulation of settlement.
In addition to the couple of conditions we talked about tonight?
The conditions that were raised by the board, by Mr. Pepe, to which I've already responded, can be deemed incorporated by the applicant into its offer of settlement.
Okay. So Mike, as I understand it, the next step in this process would be a motion by one of the board members to approve the proposed settlement with the conditions we've talked about tonight. Would you go through what those conditions are? And you don't have to list everything. I know a lot of them are carryovers.
The conditions, well, conditions are twofold. First, Mr. Pape's gone through every one of the changes that are part of the settlement agreement. So that's been gone through ad nauseum. With respect to the other conditions of approval that flow over from the prior proceedings, they included lighting to be 2700 Kelvin light fixtures, perimeter lighting on motion detectors, overnight lighting reduced to lower intensity, no light spillage onto any adjacent property with the exception of the intersection of Route 33. Landscape maintenance plan and long-term maintenance by the property owner, as well as permanent maintenance of landscaping and the sound wall is to be included in the developer's agreement with the municipality. There's going to be compliance with the outstanding recommendations of the Shade Tree Commission, and that will also include, as indicated this evening, the report from your arborist that they've agreed to comply with as well. So that's going to be, I have that as an asterisk, as an add-on to that condition. Compliance with the technical recommendations in Mr. Shafai's report. Natural vegetation existing along the perimeter is to be preserved. Gaps in the natural vegetation as located in the field to be supplemented or filled in. There were also comments in the arborist report relating to that will be part of that as condition as well. The four-season plantings, as directed by the board and the Shade Tree Commission, four-season plants, 10 to 16 feet in height. There was a pocket of diseased trees toward the entry drive on Route 33, which should be removed and replaced with four-season trees. Drip irrigation system will be provided on all landscaped beds and berms. Utility service will be underground. The applicant's going to comply with the fire department reports. There will be compliance with the recommendations of the Environmental Commission as well. That's their October 5, 2023 report. Landscape materials to include four-season trees with a height of 10 to 16 feet. The fence that we spoke about earlier will be solid vinyl of a muted earth tone. Warehouse building roof is designed structurally to be solar ready, as was testified to by Mr. Radasti. 8 EV parking spaces will be provided. No trailer staging. Any soil importation or removal will be subject to board approval pursuant to the ordinance requirements. Warehouse operator to maintain on-site an alternative power source vehicle for moving trailers. The source could be natural gas, propane, or electric, not diesel or gasoline. The alternative backup source is commonly referred to as a mule, pony, or terminal tractor. In lieu of backup beepers, the vehicles will be equipped with a backup swisher so as not to have a sound issue with those. There will be no on-site repairs or maintenance of vehicles and equipment, no outside storage of vehicles, materials, or equipment, with the exception of what was just indicated, the mule, pony, or terminal tractor. The wet stormwater basin will be fenced. The berm and landscaping will be designed and approved by the Shade Tree Commission board and board engineer. The wet pond may have a bubbler but not a fountainhead. The site will be regularly maintained and mowed throughout the site with no, quote, tall grass, end quote, with the exception of any grasses or plant material in conservation easements, wetlands, or wetland buffers where such activities are restricted. Any wall and sound barrier will be constructed to withstand hurricane force winds, and landscaping shall be maintained by the property owner. Signage will be provided in appropriate locations on the property. We spoke about that, no jake brakes, no engine braking, and the applicant has agreed to do additional signage with respect to the circulation and the external road system. Stormwater system will be a private system maintained entirely by the property owner pursuant to an operations and maintenance manual approved by your board engineer. All recyclable materials are to be stored inside the warehouse building. Warehouse class, as testified this evening, is going to be use group S1, moderate storage, hazard storage. Any change to a higher standard requires approval coming back to this board for approval. No storage of hazardous materials, chemicals, or the like on site. Post-construction sound level tests will be performed during full operations to confirm that day and night levels are at or below state limitation levels. If not, corrective action will be taken to bring levels into compliance. Measurements to be taken at adjacent property lines and at residential buildings. Office roof air conditioning and heating units for offices will be fully concealed from view. Warehouse heating units will be interior. Applicant will complete the purchase of 2 non-conforming residences on Dugan's Grove Road and abandon those pre-existing non-conforming residential uses to be utilized for approvable conforming highway commercial uses. Provided landscape screen to be reviewed by the board engineer if accepted by the adjacent property owner for lot 40, block 20.01, but that's up to the adjacent property owner. And no backup of trucks along the northerly side of the property between the hours of 10 p.m. to 7 a.m.
Thank you, Mike.
Sorry, Mr. Stein, can you add for that fence comment that it would be the earth tone solid fence?
Yeah, I think you
did.
Thought I said-
Yeah, I thought he said,
said
maybe he
earth
didn't
tone.
say the word solid, but, yeah,
Muted earth
Solid
tone,
vinyl.
solid vinyl.
yeah, I think we got that.
I probably didn't say solid, I did say
Yeah.
vinyl, but it's solid vinyl earth tone, muted earth tone.
With that, it's the board's role now to proceed with a motion. Once we have a motion and a second, we have an opportunity to deliberate, and then we'll proceed to a vote. So I'll take the liberty of making a motion to approve, subject to the conditions that Mike has outlined for us tonight, and see if anyone would like to second that motion.
Second.
Okay, thank you, Tom. Now's an opportunity for any board discussion. This has been a long application, and we've gone through a process of reaching a settlement and a resolution. But of course, we have an opportunity to talk amongst ourselves and then vote. Any further comments or conversation before we call the roll? Okay, seeing none, Danielle, please proceed.
Chairman Newman.
Yes.
Mr. Pito.
Yes.
Committeeman Ziner.
Yes.
Committeewoman Zabrowski.
No.
Mr. Lambros.
No. No.
Mr. Pepe.
Yes.
Ms. Sinha.
Yes.
Motion approved.
Okay, thank you very much.
Mr. Chairman, members of the board, board professionals, thank you all.
We'll give you a minute to step out and an unofficial break, Angela.
Or you could test this movie later.
You get to go do that.
Call me and I'll have someone there.
I'm guessing it'll be 3 years, 4 years from now. Like, I'm gonna go through conditions, all this.
Oh, yeah. It's gonna be a lot shorter than that.
Is there anyone here? Mike?
Part of our master plan has to be,
Ken is here.
But is he doing anything?
I don't know, I told him it was on.
none of them are. But the problem is they don't have a vet.
See you, very good.
Thank you, Mr. Chairman.
Pardon? Yeah.
I'm sure he regrets the phone call.
It's hard to explain. I know. It's even worse.
So how do you know it's township open?
It's just like to continue to.
I know it's mine. It's your turn.
I think we've done a great job. What we could do, but
Hey, could have
18
passed
feet
without
of
the,
dirt.
with the variances. Could have passed.
18 feet of dirt is a pretty aggressive thing to build. Like, think about it, you're building something that's almost 2
Hey,
stories.
Ken, are you staying or going?
I think I'm going, unless you tell me I'm staying. I was told there was a discussion, but not one that I was involved in.
Correct. I
Ken,
think that's.
thank you for, off the record, for the consideration. Thank you.
Angela's not typing, so you.
Yeah.
She's like backing up.
I mean,
She's like, I'm done, out of here.
No, I think we expect you to go.
see
you later.
how often I get sued.
Could you call me later tonight?
No.
Good answer.
I'll call you, but what are we talking about?
Good night.
Looking for a friend?
Yeah, lifeline on them.
No, you can.
6-foot fence on top of it, you have 24 feet from blockage.
Chris, we're gonna get back, we have another item on our agenda.
I'm ready to go.
I'll get off the
This one's
desk.
leaving.
Oh, right, you have to go.
I gotta go off, yeah.
Okay.
Can I sit there or no?
I think for this you can,
Yeah,
yeah.
we're not gonna-
Application, there's not gonna be a.
There's no public comment, so you're welcome to sit there.
This is just an internal discussion.
Yeah, all right, so, Angela, you okay?
Yeah, I'm
All right, we're back on the record. We took a short break to allow the prior application to clear out of the room. For the record, Tom has stepped down. The last item on our agenda is something that he has a conflict with or familiarity with, so he'll just sit in the audience. So, Mike, the next thing on our agenda is board discussion of I'm not gonna say this.
RB Antico.
Matter, so, Mike, I'd like to turn it over to you to introduce what we're talking about.
Very briefly, this was a subdivision that was presented to and approved by the board. And the approval required that a conservation easement be placed over a portion of the property relating to wetlands and wetland buffer. The standard conservation easement that is normally approved provides that the property will remain in its natural state and is restricted from the removal of trees and ground cover, with the exception of the removal of dead or diseased trees. When the conservation easement for this application was provided in connection with resolution compliance, the easement had some language that was not part of the standard language. And that easement provided that the easement was granted subject to exceptions for pre-existing conditions of the property, including curbing, pavement, walls, fences, buildings, which will remain on the property, and also provided that the easement was subject to the maintenance, repair, and replacement from time to time of those structures, which is different than the normal language in your easement, which says you're going to allow it to grow naturally in perpetuity and just leave it alone. So that raised a question as to these features, and it also, that conservation easement also had drawings with it showing where this, I guess this particular type of a dirt roadway or path or trails
That went through the buffer area.
that were through the buffer area that were not shown on the plans that the board reviewed when it granted the subdivision approval. So that raises, in my mind, two potential questions for the board. The first question is, if you were aware of those conditions at the time that you granted the subdivision, would that have changed your decision to grant the subdivision approval? If not, no big deal. If so, and that's where I'll dump on Matt to give you a little bit, let me finish though, as to whether or not this has any impact upon the actual subdivision or not. And assuming that it would not impact your decision to grant the subdivision, are you okay with this language about allowing the maintenance of these conditions, continuing maintenance? Or do you want them to just let them grow naturally and forget about maintaining these conditions because they're in a conservation easement that you want to remain as, unencumbered and left in to develop naturally? So those are the two things that I think are what the board is looking at, and I'll just ask Matt to give you
That's really
a
what it came
snapshot
down
of.
to. I mean, it was the first time we had a conservation easement document that said that, and all of a sudden it showed all this clearing, which was never part of our original plans. I mean, apparently, but they did get a tree clearing permit in 2022, which was right before we approved it. So, but somehow the plans never showed it.
Well,
But again,
in this case, if the gentleman, or whoever owns the property, cleared some trees, and that's the real offense to it, why can't he just replace the trees?
There's a dirt bike
Because it's a dirt bike
course
trail, that's what we're saying.
in its place.
Wait,
he's
is the
saying,
di- is the-
he's
well,
saying
hold on,
he
hold on.
did
Is the
not.
dirt bike trail on the conservation easement, which is part of the open space of the land?
It's in the conservation
It's in the
easement.
conservation
It's in the
easement, yeah.
conservation, that's the way I was understanding it.
The open space that was sold
dirt
to
bike
the
trail.
Yeah,
town,
but the dirt bike trail
county
is not
is,
It's separate.
so,
It's not in the,
it was not part of our
it's not in the
subdivision.
for sale.
Just for me, just to take it back a little bit, so there's a dirt bike trail in this thing, which is not an official thing, you're not allowed to ride dirt bikes anywhere in theory, right?
On
They're not
private
licensed.
land, you can.
Okay, and private land, so it's private land, but it's in a conservation easement. Can you tell the guy don't ride his dirt bike in the conservation easement? Can we be reasonable with this guy or no?
Conservation easement by definition should be let to grow to meadow. It's
I'm
not supposed to
told
be maintained.
we're told he's not riding a dirt bike over there.
I gotta tell you another
I'm
thing
just
too.
telling what we've been told, so.
Let's be honest with each other too. If the guy says, I'm gonna do whatever you want, he's gonna continue to ride his dirt bike there. And let's be honest, there's no enforcement in this town. I have baseball field lights that are turned on constantly, blasting in my house. That's a real easy one to fix, and it never gets fixed. And this goes on for years. I have zero confidence, that this township will be capable of maintaining or stopping somebody from riding a dirt bike in a conservation easement. Let's be honest with each other. We can't stop outdoor storage, we can't stop fences. I see that Medco Paving, or those guys, they basically cleared like another 10 acres behind their property. We don't stop that? We think we're gonna stop a kid from riding a dirt bike? Come on. Let's be honest. So we want to bust this guy's balls over it? He cut down some trees, plant some new trees, tell him not to ride the dirt bike in there. He's going to tell you whatever. And guess what? The kid's going to ride the dirt bike in there. Are you going out there on Saturday going to stop him? Are you? Is anybody here?
So are you
Let him at
saying
least
to
plant
let
the
it
trees.
be, or plant the trees?
Plant the trees definitely, okay? That's fine, right? But you're not going to tell him. You can tell him to do whatever he wants. We're talking about stopping cars from driving on roads that are not, trucks that are not supposed to drive on roads. Are we stopping them? Are we doing anything about that? When we did the Pepsi Cola thing out by 130, and we said there's not gonna be any outdoor trucks are gonna not be out there idling at 5 a.m. or whatever we did out there, who's going out there and checking on it? Vesuvio's Pizza, I love those guys. They're great people. I know them for the whole time I've been in this town, 30 years, whatever it is. They have outdoor storage. Is anybody stopping them? So come on. We're gonna stop a kid from riding his motorcycle in some dirt, in some conservation easement.
Enforcement aside, I think the issue is just, are you making him get rid of the dirt bike track, or are you letting him keep it with that language
What I'm
that
saying
Mike
is that
read?
you're telling him to get rid of the dirt bike track, is that really, he's really gonna get rid of the dirt
Well,
bike?
that's what, he has to do what Jeff said, where he has to let it
Grow to meadow.
grow to
Okay,
meadow.
and then when the kid rides a dirt bike on there again, what happens?
Somebody has to report it, and then it gets enforced.
I think part of the other question is,
I can't throw my hands.
easement areas are supposed to be free, no tree clearing, no anything, and does it require variance? Is this something that needs to be done by board with an official action, or is it something that can be done administratively?
But we have no violation issued on this property.
Well, we just became aware.
Nobody
of
has
this encroachment.
reported any tree removal anywhere on the conservation
Actually, I don't
easement.
think that's true.
I haven't seen it, and there has
I believe
been,
it was.
I haven't, again,
Let's assume somebody has reported this tree removal. The first thing we should do is put the trees back, right? That sounds like a reasonable thing, right?
Yep.
So that's act one. Two, let's be honest with each other. You tell me,
You going out there? You guys going out there?
It's code enforcement that goes out there.
Because you have a code enforcement.
But you don't have it.
Let's go back to the original
And does
question.
code enforcement
Yeah,
do
we're
it?
gonna go off track.
The original
If they're
Code
question,
enforcement doesn't stop those Batesville lights from going on in my backyard ever. So what makes me think there's gonna be, why should I have any
Have your
confidence?
code enforcement to,
I've called just about every township committee guy. I don't call you because you're my neighbor. I don't want to bust your balls. But I think I've called everybody else. Starting with Nancy when she was on the board, starting when, you name it. We're starting with.
Have you
the guy
called
who's
the
toilet bowl
actual
baker,
code
that guy,
enforcer
remember
who
that
gets
guy?
paid to do this?
Right, that guy, the fat guy, he looked like a pig. We got that guy, called him up. No, come on, let's be
Well,
honest.
the question is,
You guys love that I show up to these meetings, don't you?
but anyway, no,
The
the
enforcement-
question, the original question was.
Yeah, that's what we lost,
There
the
was a
original question.
there was a subdivision granted,
yes.
and there was some, this cleared area was not a part of the record,
it
correct?
was never in our records.
And right now, it's an easement, and it's not being used.
It's a conservation
And it's not
easement.
being ridden on, and it's not doing any of that, right? And the question is, would it have changed your mind if you knew that a land that was part of the subdivision had some trees removed and was not being used anymore? That's kind of what it is, right?
That's, again, that's the first question. Would that have changed your decision on approving it or not?
Che-
Was I on the board at the time?
Yes.
This happened?
Yeah, you
Yeah.
were.
Yeah, this was just like
So
6, 7 months
I
ago.
don't think it would have changed my mind,
It was 2 years ago.
It wouldn't have
2
changed-
years ago.
especially if it's not gonna be used.
It wouldn't have
He
changed my
said-
mind either.
Matt just said it was 2 years.
I don't know if tree clearing requires
But
variance.
if you're saying that if he cleared some trees,
Conservation easement is that, you're not supposed to touch a conservation
Right.
easement. That's how all the conservation easements are in
Do
this
they
town.
trigger
But I think
He's
the
saying
but I think it was
he's
touched
not
before
touching it
the
anymore,
subdivision
or
came in.
never did. The trails were there before.
Before when? Before or after
Before
the
he bought
subdivision?
it. Before he bought it.
Then fine, as soon as it became a
And
subdivision with a conservation
He
easement, the
has
conservation
no
easements go back to
plan of
natural.
taking trees down. He just
time out.
want this to go and maintain the trees or something like that. I'm not sure what he's using it for.
So he didn't put in a track after the approval,
That's
and
what
he
we've been
didn't
told.
take down trees after the approval. But
Well, that's suspect.
But it just wasn't on the plans that we saw for the approval, is that what I'm
Right.
understanding?
Right.
Okay.
yeah,
But I think if you guys saw that on the plans, knowing this board, a condition of approval would have been to return whatever was in the conservation easement
Back
back
to
to
natural.
natural. That would have been a
Back to
condition of
And that's
approval.
what is the guy asking to continue to use the conservation easement?
He, on his conservation easement document to file, he wants a language there that there is a 30-foot trail, that he wants to leave it there for,
No,
what?
trail goes away, land goes back to natural. You don't have one-offs on conservation easements because you get an exception for everyone in the town.
If I may, I'll just read, it's one paragraph. I'll read
Yes,
you exactly
one
what is in the conservation easement that they're proposing. This conservation easement is subject to exceptions for pre-existing conditions that predated the creation of this easement. Those exceptions more fully set forth below shall remain. The improvements include curbing, pavement, walls, fences, buildings, all of which shall A, remain, and B, shall be subject to maintenance, repair, and replacement as required from time to time.
So that's more than just a dirt bike track.
That's what I was just
So-
gonna say,
so
so are
hold
we
on,
sure
hold on,
that
hold on.
that's all that's there?
That would have
That's the
changed my
buildings
mind on
that's
the
there.
application, in all honesty. Because if you're defining a buffer as a conservation easement, it's supposed to be natural. There's not supposed to be any structures, any clearings, or anything of such.
Well, what structures are in there?
That's what I was.
He's saying
Well, the question,
fence.
let me separate it into two compartments, okay? The first compartment is the fact that these things were there would that have changed your decision on the subdivision? And if not, because, hey, they're already there, fine, but we now are putting in a conservation easement, which is step two. If step one is, no, it wouldn't have changed my mind, we still grant it, but it's granted subject to a conservation easement, then question two is, are we enforcing the conservation easement as the standard easement? It remains in its natural state. And this stuff about maintenance and repair and continue gets
Swept away.
swept away from the easement language.
Yes.
So my question is it really a conservation easement if there's all those items that you just listed
So
in
what,
there?
what happened is that this was there before, when the land got sold between the county, us for open space, and them, when they created the new subdivision, the conservation easement was to become a buffer.
Right,
So this new conservation easement went through this area.
that the buildings were already, or whatever was there.
Correct. So now the ask is, can we still keep this, or do we have to really make it go back to metal?
But we didn't
And we didn't know
about
that
Right, that's
at
the
the
thing,
time of
yes.
application.
Right, so
That's-
how we didn't know about it, no need to go backwards and
No.
figure that out.
So we go forwards and we say everything goes to metal. It's a conservation easement. It can't be touched.
Right, so.
Leave it as it is in a conservation easement.
Yep,
So you're saying leave all the buildings, the fences and everything there? Is that what you're saying?
yep.
Okay.
But you're,
I'm-
I
yeah, I'm
thought,
confused.
I thought you were saying, but those items have to go.
Yeah, go.
But that's what, you
Yeah.
just said the opposite when I just
no.
asked you.
My mind, it goes cleared back to
It turns
metal.
into natural land with
Natural
trees and
land.
bushes or whatever, nothing else.
So no fence, no buildings, whatever's there.
Does anybody
Jeff,
have
is
an
that what you're
idea?
saying?
Yeah.
Are these
Okay.
structures?
Take it down.
Are they, what are these structures that are being talked
Okay.
about?
You
Sheds,
say
are
take them
they-
down, is that what I heard?
Jeff wants them taken down, take
Take
them
it
out.
down.
Yeah.
What are
It's a conservation
What
easement.
are the structures we're
It's
talking?
in his.
It's in whatever he just read,
The
yeah.
fence,
Yeah, but what is
It
a
says
fence?
it, I haven't,
Well,
I haven't
it's
seen
not-
anything that shows these structures. I've
There's
seen
usually
something that shows the
fences.
paths.
he never showed us any structure
They don't
till
know 'cause it
this.
was never
It's not his
designed.
principal, it's not the principal dwelling, right?
But this
It's-
goes to the heart of the matter. We
accessory.
didn't know about it back then, and we still don't know about it. All we know is that something exists, so it feels like it's bothering us enough
Yeah.
that this is not an administrative approval or anything like that. The applicant needs to come back and tell us, okay, I'm
With an
gonna sign your
application?
conservation easement as you always have it, and I'll take care, I'll wipe these structures out. Or if he wants to leave them, come and ask us that question as a part of an application and get Chris's wrath.
But he doesn't have to redo his entire application.
He would still have to file permits,
Probably not.
maps, whatever, as part of an application process.
So he'd have to go through all of that again.
Yes.
Doesn't that seem like an undue hardship to the guy?
My sense would be to make them come back requesting a clarification or modification of a condition of approval. The condition was a conservation easement, and they're asking to allow these things to remain and not, and to maintain them. And they're either gonna, you're either gonna say, fine, they can remain, you can maintain them, or no, you gotta get rid of them.
No.
Can we ask for an updated survey as part of that, so we can see all of these?
Well, absolutely, I
Yeah,
think the
I
board
wanna-
wants to see.
Yeah.
Updated survey,
What things
where
are
the
and what
conservation
aren't.
easement
Alta
is.
survey so we could see
What
what
is
the
there
deal
today
is.
as far as things that shouldn't be in a conservation easement, that's there going through the conservation easement?
Well, this gentleman had livestock on this property, if I'm not mistaken, correct?
He
Tom,
still-
comment.
He still
He still
does.
does.
comment as a resident?
Yeah.
Well, Mike?
We're off the reservation for a moment, so go ahead, we're gonna wrap this up quickly.
I want to state a fact, okay? And this is the fact. There is no dwelling in this conservation easement. There is no fencing, there is no curbing. It's natural, raw land. There is no motorcycle track. Period, end of
I know
story.
what brought that up.
Okay,
So
it was,
You can see
it
it,
was
it's the
a,
aerials.
it was a trail, a logging trail back then. And associated with that, what happened was, when they had the horses, they used it as a riding trail.
The problem though is.
But that's why.
Now, that's good
Then that's
intel,
fine,
but
so
that's
nothing
not.
needs, nothing needs to be removed.
No.
Have it go back to conservation
Well, I'm
easement.
just saying, there's no dwellings, there's no fence.
Except
So
the
there's no
the
curbing.
It says it,
language they
right?
proposed.
Except that they
Yeah.
put in
I
the
don't know, that
language.
language is bullshit.
But,
That's what they
but the
want.
applicant put it in is what the problem
I
is,
know,
right?
and that language should be struck
Yeah.
from the
And
conservation
that's why they're
easement.
gonna come here.
We-
and
that's
we're
why we
gonna
need
tell
them to
You
come
want a
back.
modification to add that language? The answer is
Does that at
no.
least
Correct.
start
I
off
don't
from, does he have to then do all the things you suggested,
A request
surveys
for
and so on and
clarification
so
of a
forth?
condition.
We need to know where these things are. I mean,
Okay.
if there's,
Well,
I'm
it's,
just curious, what if there's, but how about if the answer is there's nothing there?
then fine, then it goes through a conservation easement,
Then
it goes
why
to
did we put all
natural.
this
That's what I was gonna
mumbo
say, it
jumbo?
makes
Yeah,
me
I'm
think that.
confused as well, but I
Yeah.
wonder who put that in there.
It sounds like they want to do that.
I guess Ken drafted it.
Actually, that's
Which
maybe
is-
more the case.
which
They
is
they
sort
probably
of,
want to put a shed back there, they probably want to put a
that's
a
the benefit
motorbike
of
trail back
having them
there.
do another survey, and
that's
we'll
probably
know
more
that there
the
is or is
Yeah.
not a fence there.
They're trying to sneak it
I
in.
think that you bring them back with a request for clarification of the condition. They bring in a survey so they can show exactly what it is that they mean when they talk about these structures on the
Yep.
property. So you can see exactly what's there, and then you clarify the condition.
Get an aerial of it too.
Why would they add
Fly a drone, get an aerial.
I would ask the board to see if McKinley can confirm, because the way I read the ordinance, if there is going to be anything other than bringing it back to the natural state, that it does require a variance, and that can't be done administratively, which is the cause
That's an
of my
application.
question in the first place, because it says in our ordinance that
even for pre-existing, like if it was there before?
if it wasn't, we have the survey from the previous, when they came to the board, it wasn't there.
Okay, so we think they're lying.
I'm not saying that, it just was not shown in the
Okay.
previous survey.
Yeah.
It's on the current conservation easement
Okay,
program that-
I'll double check the language to see if it would trigger variance. Yeah, I can't
That-
remember off the top of my
That's why I
head.
was concerned with doing something administratively.
So you want them to come back here to
For
go
clarification
over
of the condition.
conditions?
Clarify
Correct,
what he
to
means in that
clarify.
There are
language.
other conditions that he's also questioning too. So
Well,
we
Such
could
as?
do them all at the same time.
Yeah, right, bring it all on.
Yes, just-
Yeah.
just have a
Chris,
conversation.
we need you for that meeting.
There is,
Schedule it
there
way in
is,
advance.
one
The
thing-
schedule's not getting
there
any
is,
better.
The reason why I say this is because the Meadows got all kinds of crap when the development was done and there was a conservation easement that went right through the center of the Meadows. People were mowing it, keeping it clear. We were told at that time that you can't mow it, it's gotta be meadow. Which wound up to be good, because now we have like a mini forest breaking the development in half. So that's the idea of a conservation easement, is to keep things natural looking in the town. So this should not even be allowed as
Yeah,
part
so
of any
Let's
language.
see what their deal is, because, right, it doesn't make sense what
Yeah,
we're
Let's
reading.
get the
versus-
application back in.
Doesn't make sense at
All
all.
right, so Danielle,
That would
you or
be-
Michael follow.
Here's the thing too, I don't know where the trail is on the property, but I do know that the property was subdivided and like, I think 75 acres of wetland was sold
Was-
and preserved.
The county and the township
Yeah,
bought it.
and I think that this easement is between that big wetland
Yes.
and the property that the house and everything else is
Right,
on.
so it's the buffer between the land that's bought by the public and his five little pieces
It's
of
5
land.
acres, right.
Two of which are non-conforming.
Yeah, there are not two non-conforming lots.
Right, lots D and E were non-conforming lots. There were supposed to be 6-acre lots, but we gave it to them at 5 1/4 and 5 1/2.
Right, because there was preserved land associated with it.
Right,
That was the motivation.
Yeah.
yeah.
Right.
So we
But
did
that's
him a
still a
favor,
big
so he
lot.
should be.
Physically. But whatever. I mean, all right, let's just get it back in here. We'll take it.
I do have one condition which I need you guys, if you could waive it.
For this,
Environmental Commission asked for an endangered species study
On his land?
on his property, yeah.
Why?
There's wetlands there. With every wetlands, we do a
Yeah,
study.
but we've already.
But he went to the state,
Yeah,
wetlands got approved, and
No.
he got 150-foot buffer already. So
Okay.
we can't even add to it.
No.
So I'm asking if we could waive that condition.
I think we should waive that.
That's,
Because even if we can add to the buffer, that by state law, we're stuck with that 150.
We've learned that.
right.
We just learned that recently, so.
We can't
Unless
enhance
you
it.
want to
So
find a
at least
trash.
we could waive that condition.
yeah,
Because he was gonna go back to EC, discuss it, I said, let me bring it up here, so.
no.
Yeah.
We'll waive
The
that.
buffer's the buffer, and
It
endangered
is,
species
and
will
I-
have to live on
I
that side of the buffer.
I don't want you-
We'll tell them to move.
Because it came
What
off.
can I tell you?
All right.
Okay, I think we're at the end of the road on this one.
Yeah.
So Danielle, Mike, you know what to do on this. I don't
Adjourn.
think- Anything else on our agenda? Nothing I'm aware of. We have a special meeting coming up.
We have a special meeting coming up. I
Just-
was waiting until after today to send out the notice so everybody didn't get so confused with trying to zoom in tonight, but
Okay.
we've also been looking through some Zoom issues, so I think we have it figured out. We've upgraded our servers with the township with some of the notifications on, the PIN numbers that they give you with the Sorry. I think we got it all figured out.
Okay,
Send
just,
that out.
do me a favor and resend out the invite?
I
Is it-
didn't send it yet,
Okay.
because just this week.
I thought it was the 23rd or
It is
24th.
It is on the
I didn't send
23rd.
the invite out yet.
Yeah.
I can
Is
send
it
the
what,
link.
3 o'clock, 4 o'clock, 2 o'clock?
3 or 2,
Yeah.
yeah. Something that was
I know
good
I
for
would.
me.
It's during the day.
Figures, not good for me.
It's during the day.
Yeah, me too, that's
I
why.
did send an email, but I didn't send the link.
We have a motion to adjourn.
Oh, sorry.
Motion to close?
He's leaving, so I'll take it. We have a motion to adjourn on the table by Mike. Is there a second?
Second.
I'll second your motion, Mike. All in favor, say aye.
Thank you.
Aye, we're adjourned.
You guys are really glad I came.